Hello and welcome to our YouTube channel. My name is Shubhashish Singh Rehal and you're watching IAS Primers. In this video, as you can see, we are going to learn about the Sedition Law. And our focus is going to be UPSC Civil Services Mains. Now, this is a topic that is quite often mentioned in the news. As you can see from the images itself, these are very famous and very popular cases that took place in the recent times. So sedition, as you can see, this is the case of climate activist Disha Ravi, right? So she was charged with a sedition case by the present government, and the sedition case was basically under section 124A of the IPC. She was basically accused of something known as a toolkit, which is basically a propaganda material on various subjects. So it was on climate change, it was on farmer agitation, it was on atrocities by Indian Army on the people. So various material was there which was a kind of criticism or dissent against the government. And then you can remember this case of JNU students, the famous JNU students, right? So they were again charged with sedition. So we have number of cases including very famous personalities like Shashi Tharoor, Rajdeep Sardesai and many other journalists who were booked for sedition in the course of time. Since January 2020, more than 3,000 protesters have been charged against the Citizenship Amendment Act. Basically, they were the protesters who were protesting against the Citizenship Amendment Act, and they were charged with section 124A of IPC, that is sedition. And then in 2019, I'm not talking about 2021 because we have a major farmer agitation going on. So in 2019 also, more than 3,000 farmers were charged with sedition who were protesting about land disputes. So there are n number of cases about sedition. Some are very famous, some very popular, and some which are very routinely which would go unnoticed into the common eye. So in this section, we are going to learn about the sedition. So let us see what is sedition. Sedition is, let's come to this slide itself. Sedition is an act of inciting a rebellion against the state or monarchy. So sedition is basically something that incites a rebellion against a state or a monarchy. In India, the sedition is defined by a law known as section 124A of the Indian Penal Code. So for all practical purposes, we'll be looking at section 124A. So as per this, sedition is a crime under section 124A of the Indian Penal Code, and it defines an offence under sedition charge as and when any person by words, either spoken or written, signs or any visual representation, anything basically, that brings, this is important now, that brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by the law. I shall repeat, it is basically to do anything, it is to do with anything that excites disaffection, or even if it attempts to bring about disaffection towards the ruling elite, towards the ruling government, which is established by the law, right? So elected representatives primarily, and also the permanent executive like district magistrate and all those public functionaries basically. So excite disaffection against any of them, then in that case you can be charged with section 124A of IPC. Now that means, let's say I can speak anything against the government, I may say anything against the government, and I may be inciting disaffection against the government, right? I may say something against Prime Minister Modi, and that means I am inciting disaffection amongst, my fellow men, and I'm against the ruling class. No, it is not the case. It is very important. It is very important that there is an effort to incite violence. Either there is something that tries to incite violence, or a violence has taken place. Only then section 124A of the IPC stands. Clear? So attempt to violence is very, very critical over here. However, very often we see that this definition of sedition, the governments have a tendency of putting anybody behind bars on the charge of sedition under section 124, as they would say that somebody has done something to excite disaffection. But the test, basically the litmus test, that is, has the violence taken place or an attempt has been made to create violence, that is not fulfilled. So people have been charged under this section 124A of IPC. Okay. Now coming to the punishment under sedition, that is what makes the sedition law very bad. Now the sedition is a non-bailable offense. That is, if one is arrested, one cannot get a bail. So one cannot come out. And a person can be imprisoned for up to 3 years to a life term. So up to 3 years to a life term. Also, a person charged with sedition could be barred from a government job, and his passport may be taken away. His passport may be taken away, and he may have to be presented before the court as and when required. As and when required. Now you can see the concern over the misuse of sedition law. So anybody who is seen to be critical of the government, normally it's not anybody, it's high profile targets, but let's say somebody is targeted over here and he speaks something, so he can be taken to the court. He can be taken to the jail. Moment sedition law is applied, the person will be arrested. And then he'll have to fight the case, right? So the person will remain arrested for that time. So this is very problematic, considering the pendency of cases and the famous Tariq pe Tariq, that problem also. So this is a very problematic thing, and it has a chilling effect on democracy. So various activists, including civil society like Association of Democratic Reforms, People's Union for Civil Liberty, has cited this as a strategic litigation against public participation, or in other words, a slap litigation. Now continuing with the sedition law, issues with the sedition law. So sedition law is a colonial relic. As you can see with the image over here, so two people who have been frequently charged with sedition, right? Gandhiji and Bal Gangadhar Tilak or Lokmanya Tilak. So frequently charged with sedition during the British as they were protesting against their unjust policies. So it was a law brought about by the Britishers, basically, who wanted to rule and who wanted to curb dissent. It was created by a colonial Raj. So it is a thing, it was created by a government which was basically aiming to provide a police state. So this is a colonial relic. In fact, the very government which introduced, that is England, has abolished this in its own country. And likewise in many other countries, especially liberal democracies, the sedition law does not exist. The second concern with the sedition is that definition of section 124 is very vague. What constitutes, citing disaffection? What is disaffection? That is very vague. Anybody can be taken up. So on the whims and fancies of the people who are in the power, this law can be misused. Then it has a chilling effect on the freedom of speech and expression, and also liberty of a person. Or in other words, I can say that this law, section 124A, may be cited as unconstitutional. Unconstitutional because it is violative of Article 19A of 19 of the Constitution, 19A of the Constitution, and also Article 21, that is right to liberty. Because moment the sedition is applied, a person has to be taken to the jail. The person is arrested. So person can be arrested arbitrarily, so his liberty is confined. So this is problematic. Right. Now here I want to make a distinction with when I talk about Article 19. Article 19 says freedom of speech and expression, right? There is a freedom of speech and expression under Article 19(1), Section 1. But Article 19(2), Part 2 says that reasonable restrictions must be there. That is said. But this is well beyond that, it is against the doctrine of proportionality. The quantum of punishment and the quantum of, the gravity of the situation is very severe when the sedition law is actually applied. So that is the problem with this thing. In 2018, the Law Commission, it is basically a body that is created by the executive, Prime Minister, President actually. So it is a body that is created by the President, which looks into various laws. And from time to time, it gives recommendations for reformation of the laws. And in this context also, the Law Commission expressed concern over the possible misuse of Section 124A to curb dissent. So possible misuse, again bureaucrats are writing it very neutral, they have to write whatever. Yeah. Then lastly, there is a very poor conviction rate. So when sedition charge is applied, we see that the sedition rate is very, very low. So this again goes to show that many a times, the law has been applied by the police. Police is, putting the charge sheet. So it is done incorrectly. Therefore, they are not able to win the case in the courts. So coming to the fact with respect to poor conviction rate, between 2016 and 2019, the number of cases filed under Section 124A, sedition that is, increased by 160%, while the rate of conviction dropped to 3.3% in 2019 from 33% in 2016. So this is an NCRB data. National Crime Records Bureau. So this is with Ministry of Home Affairs. Okay. So 3.3% from, it is 3.3% from 33.3%. To some way we can say that before this period, 2016 and all, the sedition thing was applied with better application. But now on, there is, it's being used more freely and therefore the cases are getting rejected. That is it. Now let's see what the courts have said. The most famous case is the 1962 Kedarnath Singh case versus the state of Bihar. Supreme Court held that a citizen has a right to say or write whatever he likes about the government or its measure by way of criticism or comment, so long as he does not incite people to violence. Right? It's not that violence should take place, but does not incite also. Then in 1982, P. Alavi versus State of Kerala, the Supreme Court held that sloganeering, criticism of the parliament or the judicial setup did not amount to sedition. It is an amount to contempt of court, that is a different thing, but it doesn't amount to sedition. Now coming to 1995, Balwant Singh and versus state of Punjab. So basically this person said, Khalistan Zindabad. So the court basically said raising some flag that is Khalistan Zindabad a couple of times, which neither evoked any response nor any reaction from the public, cannot attract punishment. Court actually also clarified one more thing. I'm a bit scared while stating it, but it said that even if something against the government is said, or maybe something against the flag, so sedition does not apply. Some other law can be used, like Flag Code of India, but sedition will not apply. As long as violence, incitement of violence has to be a condition over there. Very important. So even though, now the key point over here, even though the court has declined the sedition charge on most occasions, right? The conviction rate is 3.3%. So most occasions it is declined. And acknowledged the wrongful application of law. Still, it has refused to declare Section 124A as unconstitutional. It has gone to the courts. The court has the power of judicial review, and it could have struck that, the unconstitutional provision of law, but it never did that. So there is definitely some rationale of having a sedition law. So let's see what the rationale is. One, this is the viewpoint of the court itself. The court basically says that we have in a country, there are a lot of tendencies like the Maoist separatist movement in the Northeast. So there are a lot of things where sedition is actually applicable. So to remove it on the grounds merely of misuse. So on the grounds merely of misuse does not warrant a charge of unconstitutionality. So that is one very important point that the court gave. Other thing is that if the sedition law is removed, then in that case, if somebody actually tries to willfully remove the government by the use of force or inciting violence, then this clause may not be there in that case. So this is an important point that I wanted to share. So this is it. Now coming to the question with respect to UPSC mains. So it could be framed in many ways. I have chosen this. Critically examine the contentious issues with section 124A of IPC. So you can write it in 250 words because there are a lot of arguments one can give in favor, in against. So you can write it in whichever way. So this is all we have for sedition. Thank you for streaming into this video. All the best for your preparation. Once again, you're watching IS Primers and myself, Shubhashish Singh Rehal. Bye-bye.